So let me tell you a little bit about myself, because I think it's something that will help, I think, explain why I will do a year in review talk along the lines that I do it. So I've been teaching international law generally and international criminal law for about almost every year. The number gets larger, and that kind of makes me sad in a certain sense. But it's been now about 14 years. I've been at Washington and Lee University School of Law. It's the University of Virginia. I first became interested in this, actually, however, through work at the national level in terms of prosecutions and defense work for serious human rights abuses and international crimes. And I think one point of view that I would like to bring to the table today in thinking about not only a year in review, but also the years ahead, is to underscore one very important reality, which is that the vast number, the largest number of attempts to deal with justice following terrible atrocity do not happen at the international level. In fact, demographically speaking, statistically speaking, only a tiny number of trials occur at the international level, a number that is completely dwarfed by national and local prosecutions. And one thing I would like to bring to bear in the remarks about the year in review is not only to review what has happened over the past year at international tribunals, I will talk a bit about that, but also to underscore the importance and to tell you a story or two about national prosecutions as well. Because really, if you were a statistician, if you were a bird in the sky looking down at where the action is, the action on the justice front is actually conceptually, perhaps, in The Hague. But operationally, it's in a lot of places that people just don't talk about. Okay, so internationally, what I don't want to do is review and repeat what's already been said. So I thought what I would do is boil down to a couple of observations that I have about the activities at the international institutions over the past year. And I see four, I think, qualities that have emerged. One is the quality of transition. And what I mean by this is that the work of a number of the international institutions is winding down, moving on, relocating. Second criteria or quality that I see is what I would call unevenness. In particular, with the International Criminal Court, I think we see some high highs and some low lows, and I think we see a staccato process, and I can't fully figure out if it's 2 steps forward and 1 back, or 1 step forward and 2 back, or maybe even higher numbers, probably more in the backwards direction. I don't know, all right? But I'm an optimist, so I would say that there's 2 forward, 1 back. The third theme, migration. This sort of moves on to where I had opened up. Proceedings moving from the international level to the national level and being dealt with there. And then finally, the final criteria that I see emerging is what I would simply call omissions. We heard about one on our first dinner here together, the omission of atrocity being committed and oppression being committed in the Russian Federation, where there's very limited role for justice. I woke up this morning to look at another omission that we have been talking about quite a bit. A photo I saw from the latest torture practices that ISIS is deploying. So this is a photo of 4 men on a bar. It actually looks like a swing set, and there's a bar that goes in the middle. They are tied to the bar, arms and legs like above, so they're face down. In front of these 4 men is a row of kerosene row with straw on it, all videotaped. Straw, kerosene, there's 4 of them, these 4 men are there. Their bodies are also doused with kerosene. Each of these 4 rows is lit on fire. The kerosene advances, and the men burn to death. Face down, so that, unless of course they close their eyes, they will see the oncoming flames, and you can't close your nose, so you will smell the oncoming flames. So here we see omission because conceptually we're dealing with crimes that definitely fit within the remit of international institutions, but we see nothing in terms of operation because of jurisdictional concerns. So I think if I sort of had to summarize the past year, transition, unevenness, migration, and gaps. So what I'd like to do today is 3 different steps, I think. And the first step that I would like to do is just some facts about activities at the international level. This is an audience, I can tell just by looking out, where I see some familiar faces and I see some new faces. And that suggests to me that there is going to be a number of people in the room who may not necessarily be insiders to the process of international criminal law. So in the facts, I'm also going to set out a little bit of simple background for some of the institutions. Then I want to talk to you about people, because at the end of the day, justice is about individuals. Human beings are in the dock, and human beings are the ones, not monsters, not demons. Human beings commit atrocity against other human beings. And the human beings accused of atrocity have stories. I'm not saying they have much perhaps in the way of humanity, but they certainly are members of the human collective. And I want to tell you stories about 3 defendants that appeared this past year in the news, whose stories I think are somewhat compelling, not necessarily from an empathy point of view, but certainly from the point of view of getting us thinking about what's going on. And then from the third of these 3, who's actually been prosecuted at the national level, I want to go to the final part of the remarks, which is in thinking of the year in review, looking at years behind and years ahead, and trying to excavate some of the work that has happened at the national level, which nobody's spoken about yet so far, other than perhaps over drinks and coffee, with regards to our gathering on international criminal justice. And the 3 individuals that I'm going to talk about will first be Dominic Ongwen, who will appear in The Hague, who will be prosecuted with confirmation of charges hearings in January at the ICC. Pauline Nyiramasuhuku, who's been prosecuted as part of the Title VI trial. The appeals judgment is pending, and as we heard from Prosecutor Jallo yesterday, the last case of the Rwanda Tribunal. And the third person is a person that I'm quite fascinated with, a man called Oscar Gröning, who was prosecuted in Germany in Hamburg for his role as the bookkeeper at Auschwitz 70 years after his bookkeeping. This is a national prosecution that took place this summer and is one that I think raises a bunch of interesting questions and the pivot to also a broader conversation about national institutions. So, as you all know, there are ad hoc institutions at the international level, and there's the Permanent International Criminal Court. The 2 ad hoc institutions that have done quite a bit of work demographically in terms of numbers are the ICTY and the ICTR, also the Special Court for Sierra Leone. These institutions, as you've learned over the course of your time here, are transitioning into basically their own non-existence in terms of graduating from the excellent work that they have done to residual mechanisms that are then going to take the brunt of the work going forward. And this is the theme of transition. As I mentioned, the ICTR retains 1 case on appeal. It's about 5 or 6, maybe 7 ongoing cases, both appellate and trial at the ICTY. Let's look at numbers. Since its inception and creation, the ICTR has indicted 93 individuals. 61 have been sentenced, 14 acquitted, 10 referred to national jurisdictions. 3 of the defendants passed away prior to or during trial. 3 remain as fugitives who have been referred on to this new mechanism that's been created, and 2 indictments have been withdrawn before trial. Jurisprudentially, as we learned yesterday as well, the ICTR has done great work in terms of, for example, sexual violence, associating rape with genocide, another landmark case, the media case, where the ICTR became the first international tribunal to hold members of the media responsible for incitement to genocide. So remember that number, 93. Roughly 10,000 individuals have been prosecuted at the national level in specialized chambers of the Rwandan national courts until those were effectively disbanded. And the numbers vary. But I think it's a safe estimate, conservative estimate, to say that roughly 800,000 people, perhaps even more, have been prosecuted nationally in Rwanda through this neo-traditional gacaca prosecution. Gacaca is, in theory, a traditional form of dispute resolution in Rwanda, been officialized, standardized, put in place, and roughly, let's say, 800,000 to 1 million people have gone through that particular system until that shut down a couple of years ago. So get those numbers, right? It's so disproportionate. And there's such a large amount of conversation about the ICTR, not so much about the gacaca process. The ICTY, as we learned yesterday as well, has a slightly larger number of people that it has indicted, 161. Proceedings have been completed in the case of 147 individuals, 18 of whom have been acquitted, 80 sentenced, a number have been transferred to serve their sentence, a number are awaiting that, and 52 have already served their term, which also in many instances may very, very well include early release. As I mentioned before, the work of these institutions is transitioning to the mechanism, as is the work of the Special Court for Sierra Leone, to its own residual institution. And the mechanism's work is not only to deal with ongoing prosecutions, but also to track remaining fugitives, to deal with appeals proceedings, retrials, contempt trials, also to keep on protecting victims and witnesses, very importantly, to supervise and enforce sentences. As you may or may not know, individuals convicted at the ad hoc tribunals serve their sentences in national courts that have conducted agreements either with the tribunals or with the mechanism to house convicts. This has actually led to quite a diaspora of individuals in terms of where they serve sentence. The mechanism also is geared towards assisting national jurisdictions when it comes to dealing with their own proceedings. The permanent international institution, the Rome Statute of the International Criminal Court, similarly is invested in 9 situations at present, 22 cases. There's been a great level of unevenness, again, a staccato process, forward, backwards. The situations in which the ICC is involved divide into ones where there's been referral from state parties, referral by the Security Council, independent initiation by the prosecutor, Prof. Uganda, the Democratic Republic of the Congo, the Central African Republic times 2, so 2 different situations in Mali, and state party referrals, the United Nations Security Council referrals in Darfur, Libya, and Darfur has certainly been back and forward, and the Prof. Kenya and the Cote d'Ivoire. As we also learned the other day, there are also preliminary investigations that the ICC has been involved in. The big one the past year has been this conversation about Palestine, which ratified the Rome Statute on April 1, thereby becoming the 123rd state to do so. I think in a few days, the International Criminal Court starts a new proceeding against in the Ntaganda case and has rendered judgment in cases involving the DRC. But remember, once again, the modest numbers and the large jurisprudential contribution. So I think it would be actually interesting now to segue from just these numbers to talk about people. So let me talk to you a bit about Dominic Ongwen. Dominic Ongwen has been indicted by the International Criminal Court. As I said earlier, the confirmation of charges hearing is scheduled for January 2016. And who is he? He's a brigadier commander in the Lord's Resistance Army, a group most virally notorious through the Tony 2012 video. Sort of document, I don't know the millennial term for whatever it is that you watch on YouTube, let's call it that, all right? And, you know, he is a character that has had quite the life trajectory. Accused by the International Criminal Court, the youngest individual to be accused and indicted at the International Criminal Court, he's in his mid-30s. His life story begins one day when he walks home from school. He walks home from school and he is kidnapped, abducted, and forcibly recruited into the Lord's Resistance Army as a child soldier. He says he was 14 at the time. Other documents, other reports that have some level of accuracy may actually suggest that his age of recruitment is younger than 14. But let's say he's 14. After being abducted and forcibly recruited, he fights. He is an active participant in the Lord's Resistance Army, and through skillful use of violence, coercion, empathy, pardon, and at times mercy, he rises through the ranks of the Lord's Resistance Army to become a brigadier commander. And that is in the capacity in which he surrendered in January 2015 while in the Central African Republic. In the Ugandan situation, the ICC has Office of Prosecution has indicted 5 people. Ongwen is one of them. 2 are dead, 2 are at large. Ongwen, therefore, presents as an indicted person who has suffered one of the crimes of which he is charged, namely enslavement as a crime against humanity. Suggesting to me a very interesting question: how the lines between victims and victimizers in the context of mass atrocity are often porous and permeable, not transparent, but there's certainly a translucence to them. And I think this is something that's important for us to accept and appreciate, because it's often very easy to divide perpetrators and victims into boxes that are clear-cut and categorical: good, evil, innocent, guilty. Those categories are necessary for law, but the reality of violence is often much more complicated. There's been a tremendous global push to restrict the use of children in armed conflict in both armed forces and armed groups. The push I've thought about quite a bit, I've written on it for a bit. But the protective push to shield children from violence becomes complex when an individual who is an adult, socialized, grown up. I mean, American criminal law theorists brought up this notion of rotten social background. What do you do when someone has a rotten social background and then has a propensity and a reality of committing crimes as an adult? I can't imagine a more rotten social background than growing up in the Lord's Resistance Army. So what do you do with that? What do you do with that particular situation? Does the global push to protect children from violence lead to a conversation about the culpability and responsibility of a former child soldier who has in turn, as an adult, committed serial acts of violence? Conversations in Uganda about Ongwen are complex. There's a number of Ugandans that believe that Ongwen should be prosecuted, and that conversations about how he came into the LRA are fine, but not probative. There are other individuals in Uganda who believe that Ongwen, like many, many other LRA fighters, should be amnestied, and in that particular context should be allowed to reintegrate into society without penal consequence. Ongwen himself, according to reports from the LRA, is a bit of an enigma. Ongwen was apparently among the less abusive of the LRA leaders. He drank heavily. He occasionally was capable of showing great mercy and to take risks to protect others. Will Ongwen's trial help unpack the reality of the complexity of child soldiering and the complexity of how victims can become victimizers? I don't know. Trials are geared to simple narratives, as I said before, guilty, innocent. As a prosecutor, I would not want to bring much into play about the accused's social background. Focus would be on conduct as an adult. After the age of 18, that's the Article 7 Armed Statute, that's when jurisdiction lies in that particular, 26, excuse me, that's when jurisdiction lies in that context. But the bottom line here is you can't disentangle the conduct as an adult from the socialization as a youth. Obversely, does socialization as the youth serve to excuse tremendous violence committed as an adult? I don't think we'd be comfortable with the answer to that being yes. Does it go to mitigation? Does it go to some form of institutionalized duress? I don't know. If all we see in a trial is a conversation about the guilt or innocence of the person in the box, then these questions may be less relevant. But if we see in a trial something that teaches, that messages, that instructs, that reports on the anatomy of collective violence, then we do need to have these particular conversations. Because a great deal of collective violence is committed by people who are not categorically good or evil, but who themselves have a complexity, and to me, that complexity belies the reality that atrocity itself is just not so simple. So I'm hopeful that in this trial, germinating this year, coming to fruition in the future, will serve that kind of a function. One first question I want to throw out to you is, how do you approach a former child soldier socialized in this fashion? He then becomes a leader. The second person that I want to talk about is Pauline Nyiramasuhuko, the former minister of Women's and Family Development in Rwanda, the lead defendant in the Butare 6 trial. Accused, as we learned yesterday, also from Prosecutor Jallo, together with others, including her son, Arsene. She is one of 3 ministers in the Rwandan government at the time of the genocide who's a woman. Her, there's the justice minister, who is serving a long-term prison sentence in Rwanda right now, prosecuted at the national level. And then there's a third, prime minister of Rwanda, a moderate, so to speak, within that government, murdered by her own guard after having been sexually assaulted by them. That was probably, at least on the ground, one of the opening factors that led the genocide in Rwanda to be as rapid as it was. Pauline Nyiramasuhuko flees after the genocide, found later on in a refugee camp, comes and died in 2011. Trial chamber sentences her to life. The appeal is ongoing. The question that I find very interesting in her case was a comment made yesterday that she is the only, I think there's also Plavsic at the ICTY, a very small number of women who are accused at the international level of committing crimes. And to me, this is interesting, because I think, once again, we have the reality that here is someone within a position of influence, accused of committing terrible crimes, including massive rape and sexual violence, ordered by her, including ordering her own son to commit. Very interesting to me in this case, if you read the trial judgment, it is almost recursively gender neutral. There is no mention made whatsoever of the gender of the perpetrators, other than just the initial background information. If you look at the media reports of this case, I mean, I've written about it a little bit, there's actually quite a lurid gender sensationalism, tabooification of a woman in a senior position convicted of rape, including having ordered and urged her son and others to have committed it. And to me, the sensationalism in the media goes two ways. One way in which it goes is to find her more culpable because she's a woman, because it's even more unfathomable that a woman could commit these particular crimes. So here, gender is almost trotted out to make her more guilty, therefore deserving of greater punishment. But then there's the opposite stream, where gender is spooled out to have a conversation about how there is no way that she could ever be guilty, because no woman could ever do this. And this narrative is not only gender specific, it's also parental. I can't think of a better word for it, but it's also parental. No mother or no grandmother could ever commit these kinds of crimes. She is not the only parent-child tandem to have been prosecuted in ICTR. There's another involving a pastor and his son. And the conversation there between father and son, génocidaire, perpetrator of genocide, is very different than the media conversation of mother and son. I think this case offers a portal in which to open up broader conversations about the role of gender, not only in victimization, but also in perpetration of violence, and to open a conversation about how a broader analysis of masculinities and femininities in the development of atrocity could and might and perhaps should be had, so that we could have a deeper understanding of why violence occurs, against whom violence occurs, and how gender plays both into perpetration is a very, very under-discussed phenomenon. So that's the question I'll be dealing with. The third is Oscar learning. And this is the case that I find the most interesting. Gröning is a young SS man at the time he arrives in Auschwitz in 1942. He's an accountant and a bookkeeper there. So on planet Auschwitz, what does that mean? That means that when the detainees come in, he removes from them their cash, jewelry, and valuables. He meticulously records the amounts, and he ensures that the stolen proceeds are sent back to Berlin to assist in the Nazi war effort. And he's a good, honest bookkeeper. The level of theft that occurred in the camps from other individuals who served as guards and bookkeepers into their own pocket, where they only sent half of the stolen proceeds back to fund the Reich War effort, was very large. Gröning he's an honest bookkeeper. He leaves Auschwitz in the fall of 1944 after having asked to have left 2 times before. His requests are denied. And he wants to transfer out because he sees what's actually happening at the camps, or so he says. And he wants to be transferred out. Denied. Finally, when they get the war effort, the number of soldiers gets so thin, his request to transfer out is made. He ends up getting wounded, captured. He ends up in England. He plays in some musical band for a couple of months in the UK after the end of the war. This July, a German court in Hamburg convicts him at the age of 94 of being an accessory to the murder of 300,000 of Auschwitz's inmates. He was most directly responsible in the summer of 1944 when there was an enormous spike in the number of Hungarian Jews that were deported to Auschwitz. The investigations against Gröning began in 1977, but it took nearly 40 years for him to be put on trial. He received a 4-year sentence. He's appealed. He is well enough to face trial, but it's unlikely that he would actually ever serve a prison sentence. Here are some aspects of Gröning that I think are particularly interesting. Consistently, he has acknowledged his, quote, moral guilt. Very candid about his contribution to the functioning of the camp. He, in fact, went public himself with his moral guilt and the details of his involvement through journalistic interviews, and, in a sense, did not challenge the idea of being prosecuted, far from it. What he did challenge, however, was his legal guilt. His take on it consistently sees a cog in a small machine, and the question of whether or not he's criminally responsible is to be left to judges to decide, not to him himself to say anything about it. One of the major reasons he went public with his moral guilt and his involvement is because he claims to have been so disgusted by residual Holocaust denialism that apparently was ongoing in Germany. He's a member of a stamp club. One day, Gröning at his stamp club meeting, sitting down, and instead of talking about stamps, the other stamp guy, like the fridge bracket next to him, starts saying, "Oh, the Holocaust never happened." Gröning says, "Well, I know something about that, and it did happen," and then he started to go public with his story. He, after conviction, did acknowledge his legal guilt. He also, however, refused to apologize at trial for his deeds. He refused to apologize because the enormity, in his words, of his own guilt was so large that it was simply impossible for him to get any forgiveness or ask any forgiveness from mortals, survivors, or relatives. The only entity for whom he could beseech forgiveness was the divine. So for me, the Gröning case opens up 3 interesting questions. First, is it worth prosecuting someone 70 years after the fact? What do we make of delayed justice in this regard? Is it right? To me, an answer to the question is the legal counterfactual. Is it absurd to prosecute a 94-year-old man 7 years after the fact? Or is it more absurd not to prosecute a 94-year-old man 70 years after the fact when you actually have a pretty solid case against this particular individual, in part because of his own willing participation in the process? That's a worthwhile inquiry. Secondly, once again, the victim-victimizer divide emerges here. In a lot of ways, Gröning's life story actually has some parallels, mini parallels to Angwen's. Gröning's mother dies. He was, I think, 5 or 6, very young. That's the heart attack. Father, like a lot of young people at the time, Gröning drifts into military service, SS, and so forth. He himself, at Auschwitz, never committed any violence directly against anyone. He's your classic bookkeeper, I guess part of some overarching criminal enterprise. And finally, what do we make of his statement that he has the power to admit his moral guilt, but that as a defendant, his legal guilt can only be assessed by outsiders. And he'll accept what the outsiders say, but that determinations of legal guilt are not for the accused to make. Those are three people that have been part of the game of international criminal law, whether internationally or nationally, over the past year. And I think there's a lot more to be gained, in a sense, by thinking about their stories, by thinking about what they did and the questions that their experiences raise, than necessarily just clinically going through a number of facts, figures, statistics of the machine of justice, because justice may be part of a machine, but that machine involves individuals. And there's a great deal of eccentricity, eclecticism, malevolence, but also mercy within the story of these individuals. And let me move for 2 minutes to the last part, and then we'll have almost an hour, 45 minutes for a general conversation. Or not, you guys can go get some more coffee, it's fine. To me, the Gröning case is an important pivot to look ahead, in the sense that, in my opinion, the future of international criminal justice is not going to be rendered by international institutions. I think the future of international criminal justice is going to happen at the national level, in which the norms, the law, the energy that has emerged internationally becomes instituted and implemented at the national level. But in a sense, that has been happening for a long period of time, and we don't talk about it very much. I've actually become very interested in looking at national proceedings, not in military courts, but in civil courts, after World War II, in a number of jurisdictions that have involved the prosecution of atrocity related to World War II. And this was Bill the other day. One project that I've become very interested in is an institution that hardly anyone's heard of, the Supreme National Tribunal of Poland, which operated from 1946 to 1948, and which ran 7 trials involving 49 individual defendants for Nazi atrocity within Poland itself. This is the institution that convicted Rudolf Höss, the most infamous commander of Auschwitz, for whom Gröning worked. This is the institution that convicted Amon Göth, who was the leader of forced labor camp in Krakow, played by Ralph Fiennes in Schindler's List. This is the institution that convicted a man called Arthur Dreisel, who was the regional governor of a large part of Western Poland. He was the architect of forced Germanization in that area of the country. This is an institution that convicted Bula in a trial so closely conceptually related to the justice trial at Nuremberg, in which the Polish judiciary and German lawmakers in the general government of Poland were put on trial for lawmaking. A lot of the jurisprudence of this particular institution is incredibly rich and has dealt with issues of criminal membership, sexual violence, medical experiments, genocide. This institution put in, we talked yesterday about the definition of genocide. this institution put in play a definition of genocide that was actually broader than the ultimate definition adopted in the Genocide Convention that included spiritual, artistic, economic aspects of society. So one thing I think I would encourage, younger people wanting to get into this field or in the field already, one thing I would encourage outsiders to the field is to look through the window not only of the stuff you read about that's going on in The Hague and that's going on in other centers of the sort of transnational world, but is to look for windows into places where justice happened, where people don't really look that much. There's so many underexplored, under-discussed, and very valiant and very courageous forms of justice that took place, will take place, and are taking place. And I think there's an incredible amount to learn from those particular institutions. So I guess as Chautauqua, our event sort of winds down a bit, we come here to learn about the big ticket international institutions. There's a lot of smaller shows going on all over the place in so many different areas. And they too are worth listening. So I'll stop, and I hope that some of the questions that I've raised are ones that might trigger a bit of conversation. So that's okay, I'll stop and we'll open it.